For today's story, we are discussing the first government employee that a court has found it is disqualified from continuing to be a government employee because of their interactions on January the 6th. One of the lingering issues arising from the events of January 6th has been whether it would resuscitate the little-used Section 3 of the 14th Amendment. Section 3 of the 14th Amendment provides the following. No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof, but Congress may, by a vote of 2/3 of each house, remove such disability. So there has been this question as to whether people involved in January 6th, to the extent that they would fall within this proviso, because they would have had to have previously taken an oath to support the Constitution of the United States, and it only applies to certain officials. But there's been this question as to whether people who fall into that category are disqualified under Section 3 of the 14th Amendment. And there's a question about whether or not this is automatically done, whether or not this has to be done as a result of some sort of court determination, whether this is some sort of criminal sanction. Like, how does this happen exactly? So there's a bit of dispute. We've covered this a little bit before. The law, as it seems to be, seems to say that Congress has the power to enforce this, which makes sense because that's what the fifth section of the 14th Amendment says. Congress, by appropriate legislation, has the power to enforce the 14th Amendment, including this clause. Now, Congress has, at various points in the past, authorized various officials, including state-level judges, to adjudicate on this. But there doesn't seem to be any authority that currently exists, although there is some dispute over this issue. So there's some dispute over whether or not Congress has authorized it, whether or not judges can execute against this, who has to make the determination, who decides. But the first such disqualification has just occurred, at least. The first judge at least saying that someone is disqualified. So the case involved Curry Griffin, was a county commissioner in New Mexico and founder of Cowboys for Trump. Griffin also participated in the events of January 6th. He did not enter the building itself, so there's that, but stood on an exterior landing exhorting the crowd. So he was inciting them, perhaps in a legal sense. As did so many, he had himself live streamed to his social media audience. So many of these get busted that way. In subsequent days, he celebrated the event and urged further armed activities in the future. The judge wrote that the defendant traveled across the country to participate in a demonstration, the purpose of which was to stop, impede, and delay the constitutionally mandated process of counting electoral votes and in turn certification of Joe Biden's election as president. Defendant knowingly breached barricades placed in place by the Capitol Police to prevent interference with Congress's election process. He illegally trespassed onto the steps of the Capitol, where he proclaimed it was a great day for America, as fellow Trump supporters assaulted law enforcement, smashed windows of the Capitol building, forced their way inside, and halted the electoral vote count. Defendant was then criminally charged for unlawful breaching and occupying restricted criminal grounds and engaging in disruptive conduct to impede and disrupt Congress's certification of the election. Defendant personally contributed to overwhelming the law enforcement by entering through the site of the initial breach of the Capitol Police security perimeter at the Capitol's West Front grounds, where crowds first began to flow into restricted areas and all available Capitol Police units were immediately deployed. By breaching the barricades and illegally remaining on restricted Capitol grounds for an hour and a half, defendant contributed to chaos that delayed congressional certification. While at this insurrection, defendant relished in the violent attack on the heart of the American democracy and later threatened further such attacks unless insurrection's false and debunked claims of election frauds were addressed. So the New Mexico judge at least is not having any part of it. So already. While at the a sitting government official who actively engaged in the riot itself would seem to be low-hanging fruit of Section 3. We'll see what happens next. Yeah, there's a lot of legal baseball left to be played on this one. So at least one New Mexico judge has entered the first disqualification of a person. Now, whether or not he qualifies under this for any number of reasons is a very open legal question. And it's not at all clear the judge has the legal authority to do this, because obviously no one's tried to do this in quite a while. The last time anyone was disqualified under Section 3 of the 14th Amendment was the early 20th century. So it's been a hot minute. It's been like 100 years since anyone's tried this. And some of the specific congressional authorization that had existed at various points in our country does not exist anymore, although there's arguably some authority that currently does exist. So this is going to be an interesting case to continue to follow, if he decides to appeal this, including by federal court action. It'll be very interesting to see who has the ability to decide this, under what terms, and whether or not he will be disqualified going forward. But that's at least the initial determination in this case. An interesting one to follow, at least for a moment. That brings us to the end of discussion of this case.